Be on record in cause number 29D052605F24781, State of Indiana versus Manuel Ettress. States hereby to prosecutor Ms. Goodell, by Ms. Goodell, defended by video and by counsel, Ms. Rowley. Good afternoon, Ms. Rowley. Mr. Ettress, were you able to watch the video that was played there for you at the jail, sir?
Oh, yes, I do, Your Honor.
In that video, it talked about all the rights that you have in a criminal case. Do you understand your rights, sir?
Oh, yes.
Video also talked about the range of penalties associated with the charges being brought against you. Do you have any questions about what those are in your case, sir?
No.
All right. Should have received a copy of the charging information there at the jail. Is all your contact information on that paperwork correct, sir?
Yes.
All right. Are you planning on hiring an attorney to help you with your case, or do you want to talk to me about appointment of a public defender, sir?
Public defender.
Okay. Are you currently employed?
No.
Okay. I'm going to make a finding that you're eligible for appointment of counsel. Let me see who I've got for you. I'm going to appoint Paul Kershaw to serve as your attorney. We'll get you that gentleman's phone number, contact information here shortly.
Okay.
There's been a request for the issuance of no contact orders by the state in this matter. Looks to me like there are 5 of them. Is that correct, Ms. Goodell?
Yes, Judge.
All right, very good. I'm going to make a finding that there was probable cause for your arrest in this case. Sir, I also need to let you know that because you've been charged with a felony, that you're prohibited from carrying a handgun during the pendency of this court case. Do you have any questions about that?
No.
All right, very good. State have an opinion about the possible release of Mr. Ettress.
Yes, Judge, thank you. This defendant has a high IRAS score and a high IDA score. He did not provide a cell phone number or an email address and claims to be homeless. He's also unemployed and has 1 failure to appear warrant within the last 24 months, and also has significantly more than 3 prior incarcerations, which will be addressed shortly. As the court is aware, the state has filed 26 counts against the defendant for his horrific actions on May 26th in Carmel. Count 26 is an enhancement auto theft charge based on his prior conviction for auto theft in Bartholomew County in 2022. The state has also filed the habitual offender enhancement, listing only 3 of the defendant's prior felony convictions, 3 convictions for level 6 felony thefts in Marion County, with convictions entered in 2023, 2024, and 2025. Aside from those convictions, the defendant has the following convictions from different cases in Marion County: residential entry as a level 6 felony and possession of cocaine as a level 6 felony in 2025, theft as a level 6 felony in 2024, theft as a level 6 felony in 2023, possession of cocaine as a level 6 felony in 2022, theft as a level 6 felony in 2022, resisting law enforcement as a Class A misdemeanor in 2022, theft as a level 6 felony in 2021, resisting law enforcement as a Class A misdemeanor in 2020, theft as a level 6 felony and resisting law enforcement as a Class A misdemeanor in 2020, theft as a level 6 felony in 2019, public intoxication as a Class B misdemeanor in 2019, theft as a Class A misdemeanor in 2019. In addition, he has a conviction for false identity statement as a Class A misdemeanor in Tippecanoe County in 2022, as well as a possession of a controlled substance in 2021, also from Tippecanoe County. Aside from these conviction cases in Marion County alone, the defendant has had 20 cases filed but dismissed since 2019. 15 of those dismissed cases alleged at least 1 felony offense. Turning to the defendant's pending criminal cases, he has 1 for a level 6 felony theft in Monroe County, which was filed on January 12th of 2026. He's currently on pretrial release for that case. In addition, he has 5 pending felony theft cases in Marion County, filed between June 22nd of 2025 and October 26th of 2025. He was assigned to Community Corrections GPS monitoring in each of those cases. Given the defendant's history of repeated criminal activity, failing to appear, and the egregious nature of these new offenses, the state does not believe there are any conditions or amount of bail which would adequately protect the community from the substantial risk this defendant poses. If this case had been filed after January 1st of 2027, the state could have met its burden under Indiana Code 35-33-8-2B to show that 1, the proof is evident and the presumption is strong, and 2, the defendant poses a substantial risk to the safety of any other person or the community, and that no condition of release would reasonably protect the safety of any other person or the community. As a result, the court would have the ability to hold the defendant without bond. Unfortunately, current law does not allow the court to do so, but given the state's grave concerns regarding this defendant and his clearly escalating criminal behavior, not to mention the physical harm caused to 2 people in this case, the state believes nothing less than a $1 million cash bond is appropriate.
Ms. Rowley.
Thank you, Your Honor. And I apologize that I did not receive the pretrial assessment for Mr. Ettress. I did speak with him briefly as he has been detained. We understand that he does have quite a bit of criminal history and quite a few pending cases against him in other counties. We do understand, and I did explain the enhancement to Mr. Ettress. He did testify that he is currently not working, so a bond would be a financial hardship, I believe, in any amount. The state did ask for a $1 million bond. We asked the judge to entertain less than that particular amount in any amount that the judge sees fit.
Very good. Having reviewed the probable cause affidavit in this case, the court does have substantial concerns, both with regard to the allegations at issue in this particular matter, as well as with regard to the defendant's prior noted history. For those reasons, the court will be setting bond in this matter in the amount of $1 million, cash only. Anything else from the state on this one?
Nothing. Thank you, Judge.
Anything else for the defense, Ms. Rowley?
No, Your Honor, thank you.
Mr. Ettress, do you have any questions before I conclude your hearing, sir?
No.
No? All right. Good luck to you.